Have a seat, John.
Hello, everyone. How are you?
Good afternoon.
Good to see everyone again.
Good afternoon.
Good afternoon.
Nice to see you, Judge. As you know, ready? Mike Sasso, and I have the honor of being the chairman. We're going to proceed as we normally proceed. Each of the commissioners will introduce themselves. One of our commissioners, Amanda Perry Carl, is appearing by speakerphone today, but she is participating. And then after we do the introductions, we'll give you 3 or 4 minutes to make an opening statement, and then we'll have about 20 plus minus minutes of Q&A, and we'll give you an opportunity to make whatever remarks you care to make.
Thank you.
Good afternoon, Your Honor. Vincent Citro, the law offices of Horowitz and Citro.
Your Honor, Craig Dyer, 7th Circuit Public Defender's Office.
Andy Bardos with Craig Robinson.
Mike Sasso of Sasso and Sasso, and Amanda, can you hear us okay? I think she's got us on mute. Anyway, Commissioner Amanda Perry Carl is on the speakerphone.
Brett Renton with Shetson Bone, Orlando. Good afternoon.
Good afternoon.
Nice to see you, Your Honor. Petra Brownlee with the Brownlee Law Firm.
Hello, David DeArmas, Kramer, Price, and DeArmas in Orlando.
Your Honor, Scott Thomas with Byrne Foreman.
Thank you very much.
Proceed.
Well, most of you I have appeared in front of in this capacity at one time or another. Even Mr. DeArmas, who I think is the newest member of the committee, was on the committee that sent my name to Governor Bush. So it
You're
is,
right. In fact, I know you're right.
So it's really good to see all of you again. So I'm not going to bore you with things that I've already told you in the past or that you can find out from my application. I'll just kind of fill you in on what has been happening since I was here about a little over a year ago. After I left the business court, which I left the business court at the end of 2016, I spent 2017 and 18 in the criminal, circuit criminal division. I was the trial judge. So I took trials from other judges that were kind of docket busters for them, and I helped 2 judges every week with their dockets. And then at the beginning of 2019, I came back to the General Civil Division. I haven't been in the General Civil Division since 2011. So that is what I am currently doing at this point. I will tell you each time I apply, I examine myself to see, well, yeah, I love my job. Why am I seeking another position? And being in the General Civil Division again has reinforced the reasons that I would love to be on the appellate bench. When I was in business court, it kind of brought out the legal nerd in me. I enjoyed researching and writing, and I had the opportunity and the gift of time and well-briefed motions in business court to do that research, to do the analysis, and to write and rewrite and edit and edit and edit. I'm now in the General Civil Division. We are one of the busiest General Civil Divisions per judge in the state, and I don't have the luxury of time. So it's important to get the answer right and to do the best you can to put the analysis down. It's sort of like Lucy and Ethel at the chocolate factory. I've got to get it out because things keep coming down the conveyor belt. So I really appreciate the luxury of time to sit down and to convey my thoughts and my analysis with precision and clearly. And it does take time to do that. And with that, I'll turn it over
To me.
to questions. All right.
I had the good fortune of being able to vet you, which was interesting to do many years later. And I guess my first question is going to tie into what I was thinking at the time that you were appointed last time, which is, she knows criminal law, but that's all she knows. And I was concerned about that. I questioned you about that even back then. Still, we thought you were a good person to put on the list, and I was very happy to see that you got appointed. And then when you went to the business court, I remember thinking at the time, good for her. You know, that's made, I mean, I haven't done anything in the criminal world, so if I were suddenly to be placed in that position, I'm not sure how I would handle it. Other than an internship at the Public Defender's Office in Tallahassee during school, many, many years ago. So Having said all that, tell me about the transition that you underwent when you went from the career that you'd had before going on the bench to suddenly being faced with lots of new things, and how you think that would apply here.
Well, when I first took the bench in 2003, I was put in the criminal division,
Right.
which was a benefit because I knew the law, but I did need to learn how to be a judge. And it's very different being a judge than being an advocate. After being in the criminal division for almost 6 years, I believe, I moved to family court, and that required a lot of research, a lot of reading, just to learn the area of the law. It was a good stepping stone because the rules of family procedure and the rules of civil procedure are very similar to moving into the general civil division the next year. And then after that, I had the ability to go to the business court for 5 years. And all I can tell you is with each transition, you just have to take the time to study and become acquainted and master the area of the law. The one thing that I think attorneys have learned that appear in front of me is that when I come into a hearing, I'm going to have read everything, and I'm going to be prepared to hear their argument and to ask questions. And I think that is the only way to transition into the different areas of law, is just to take the time and spend the energy to do it.
Kind of a broad question, but how would you describe your judicial philosophy?
I am a textualist, and I was one before I knew what that term meant. When I became a lawyer, I was a prosecutor, and I can remember thinking when I was a baby lawyer, and I believe it was, we had some justices on the Florida Supreme Court that weren't textualists, and I can remember reading an opinion, and the shall in the statute was being read as may, or discretionary. And I can remember being infuriated. How can shall mean may? Shall means shall, may means may. How can anyone make that argument with a straight face? I did not know that my basic tenet is to read things, if at all possible, literally, and with the intent with which the writer wrote them. And I think my writing samples that I've included in the materials show that I try to live up to that textualist belief that I have.
And I often ask questions about PCAs, but given your background, I'm going to ask it a little bit differently. How important do you think that it was when you were doing business court to give the litigants an opinion that explained where you were coming from, and how does that translate to the district court appeal?
I think especially as a trial judge, if you have the benefit of time to not just rule, but to explain the reason for your ruling, the analysis of law that you did, is important, not just for the appellate court that's going to be reviewing what you do, but also for the parties and the attorneys to know that at least if you didn't agree with their position, you understood what their position was, and that you had a reason for coming to a different result. I can remember when I was a litigator arguing in front of judges, it was always very helpful to know that the judge understood my argument, even if the judge was not going to rule in my client's favor. So I do think it's important to give that to the parties and the attorneys that are appearing in front of you, as well as the appellate court, because it's my experience that the appellate court does a better job of analyzing what you've done if you tell them why you are doing what you're doing. On the appellate court, there are times that PCAs are appropriate. There are some issues that are so well settled that it doesn't serve anyone's, it doesn't benefit anyone to write yet another opinion on that same issue of law. I mean, at this stage, there's probably not any real reason to write an opinion on the pleading standard, the motion to dismiss standard in civil. We all know what it is. However, there are many issues of first impression, and I saw them in business court. And I think it's very important to both the litigants and the population in general and lawyers that practice throughout the state to have a body of case law to look to. I can remember times when I was writing in business court and I was hoping someone would appeal me and that there would be a written opinion, just so that there would be something on that area for me to look to in the future.
Were they PCA?
Some of them were PCA. Now, as a trial judge, PCAs are awesome. But as I recognize that as a practitioner, as a member of the general public, it is very helpful to have written opinions.
What if there's a situation, Your Honor, assume, if you would, that you make it onto the 5th and you all are sitting en banc. And so you have that benefit, first of all, your colleagues are around you, and there's an issue and you're considering overruling the prior precedent, some prior precedent from the 5th. But now assume that there is this sort of collateral issue that hasn't been briefed by the parties, but you know from being a circuit court judge and even being in business court, say, for example, it's one of those issues that is sort of one of first impression, this needs to be resolved, people need guidance on this, and you know that there's a true need for it, and you have all of your colleagues around you. How would you handle an issue like that?
Well, I believe that if it hasn't been briefed, really not appropriate for the appellate court to write on it. The parties haven't had an opportunity to weigh in on the issue. And likely it wasn't argued below if the parties haven't written at least something on the issue. So I don't think you reach those issues that haven't been briefed, even though you see a need for them. And I don't know that there is a solution to that issue other than perhaps dropping a footnote somewhere and saying if this was an issue that wasn't briefed by the parties, and may need to be decided in the future, to encourage parties to perhaps write on it in the future.
I'd like to direct your attention to that. In the most recent years, in criminal cases where Anders briefs have been filed, the clerks of the DCAs have been sending the files to the judge saying they failed to brief on this issue. This is an important issue. And the courts have been sending them back and requiring that the attorneys now rebrief the case and file a merit brief on the issues that have been raised by the clerk of the court. Do you find that the future is going to be holding for the same for the civil case, and following what Petra's saying, that you guys missed the point, and here it is, go back and try again.
Civil and criminal are different animals. Clearly when an appellate attorney believes that there is no legitimate issue that they can raise with the trial court, we have the Anders briefing process. And it is a fail-safe to ensure that every possible issue that could be raised in the appellate court has been raised and briefed. At this stage, I don't see the civil law moving in that direction. I haven't seen anything in the appellate opinions that would indicate to me that there's going to be sort of an Anders process. It's an interesting thought, but I don't see that as being the future without a rule change. There certainly could be a rule change.
What if it's fundamental error, Your Honor? What if when you review it, you say to yourself, okay, no one's briefed it, but we're all sitting here, it needs to be resolved, and somehow it's fundamental error? Does that change the analysis?
Well, in a criminal case, obviously, if it was fundamental error, you might send it back to the parties and tell them to brief it. I'd
Sorry, not in an Anders situation. It can be criminal, but not
Yeah.
Anders.
But even, I think, even in a non-Anders situation, if it is fundamental error and you're dealing with the defendant's fundamental constitutional rights, I think it would be inappropriate for the court to rule on it without input from the parties. But I can see a circumstance in which it might be appropriate to ask that the parties brief an issue. I think it would be rare. It's my experience that the attorneys that appear in criminal court are very familiar with the rules and do a very good job with the criminal appeal. But everyone misses something now and then, I suspect.
Thank you.
Your Honor, in the civil context, civil cases, it's the DCA's job to get the individual disputes right, or can have a little mistake in the outcome as long as the law is clear generally? Or is that just something, that tension maybe, that the varying standards of review capture? And I ask a question, the frustration sometimes you see, like, but gee, I got a PCA just simply because they didn't want to have to write on this.
Right.
Law's fine as it is, let's don't dig into this. Not saying I just that's something you hear.
Yeah, I think I've heard that as well. It's important to get the law right, and in getting the law right, to make sure that you have encompassed the individual dispute that is before you within that correct analysis of law. I don't think it's acceptable just to say, I really don't want to write on this, and issue a PCA, if there is something to be gained by issuing an opinion.
Judge, I have an appellate hypothetical for you as well.
Okay.
So, under Florida's rules, if there's been an appeal and the parties have settled their case, you can file a stipulation of dismissal, but the court doesn't have to accept that. The court has discretion to go forward and decide the appeal. So assume that you were on the appellate court and parties have resolved their appeal, they've fully briefed it. Perhaps you've already read the briefs. There hasn't been oral argument yet. Do you go forward and decide the case, even though the parties have resolved their dispute? Do you make them show up at oral argument and then issue an opinion on that? If there are circumstances in which you would do that, what would those circumstances be?
Well, I know the Florida Supreme Court has done that on rare occasion, when they felt that the issue was one of great public importance and that they needed to give practitioners and trial judges guidance. Those circumstances have got to be few and far between, even for the Florida Supreme Court. Because if a party has resolved their dispute, I'm not sure that the law that you pronounce with regard to that case is really going to capture the essence of what it should be. I mean, that case has been resolved. Why in the world would I want to opine on something that the parties have resolved? On occasion in circuit court, you're asked to do something similar. Party will issue a notice of voluntary dismissal. The other side will say, hold on, judge. We had summary judgment pending, or you announced a ruling on summary judgment and just have not issued your order. You know, we would be entitled to attorney's fees or some other thing. We want you to set aside that voluntary dismissal. Now, in circuit court, there are some very good reasons for doing that, because someone has done it for a strategic reason that might not be legitimate. But if the parties have resolved their dispute, I would have a hard time continuing the controversy and continuing to ask them to spend money on their attorneys.
Judge, you told us that early on in your career, I think you said as a young prosecutor, somebody was making the argument that shall actually meant may.
Right.
So is there an example you could give us where shall does mean may, or is it your opinion that shall will always mean shall?
Well, it depends upon the the wording of the particular statute that you're looking at. And the particular statute that I was thinking of was actually a sentencing statute, and it says, you know, the court shall do this. And when it says the court shall do this, it means the court shall do it. Now, could there be circumstances in which shall might mean may? Can't think of one off the top of my head, but I can see that sometimes statutes might be written in such a way that subparts, you know, certain subparts may be shall, certain might be more discretionary based on the wording of the statute. So I think it would completely depend upon the actual wording of the statute.
So I'm going to give you one statute
Okay.
that you're unlikely to ever come across because it's a federal procedural statute that
Okay.
applies in federal criminal proceedings. The court shall strike from the record testimony of a witness, and the trial court shall proceed unless the court in its discretion shall determine that the interest of justice require a mistrial be declared. Are any of those shalls may in your book? I'm happy to read it again.
Yeah, I agree with you.
Whoa.
The court shall strike from the record the testimony of the witness, and the trial shall proceed unless the court in its discretion shall determine that the interest of justice require that a mistrial be declared. Any of those shalls mean may?
Some of the, they would have to, because you have two opposing things. You're either striking the testimony of the witness and proceeding with trial, or you're declaring a mistrial. So, you know, obviously there is some discretion guided by precedent, I'm sure, with regard to when you do which in federal court. But you can't do both.
That is true. And in many cases, they do neither.
We shall not do both.
But that might be the subject of an article coming out later this year.
Judge, we'd love to go with you all day, but unfortunately, I'm the timekeeper, so.
Oh, wow.
It's been,
Is it already that time?
yeah, it's been, so, hey, I'd like to thank you and give you an opportunity to make any closing remarks.
Well, I thank you for taking the time to do this. I know it's a great deal of time out of your busy schedules. And I know that you know how important your function is in vetting those that go to the governor. The position of appellate judge is very important, both to lawyers and to trial judges. It's important to have someone in that position that understands the gravity of the position and also has the ability to look at the various types of cases that will ultimately come before the court and work collaboratively with the other judges of the court to come up with the right decision. I hope I'm one of the people that you believe that can do that, but whatever your decision is, I will respect it. And I thank you very much for taking your time today to see me.
Thank you, Judge.
Thank you.
Your Honor, sir.